Right, grab a White Claw. Settle in today. We got a true legal scholar on the docket, a pro se defendant who's about to teach us all a lesson, though. Probably not the one he intends. A flurry of filings land with a thud. Got a judicial notice to muddy the mud. The judge looks confused by the arrest of judgment. While our pro se scholar files a motion to squash the whole punishment. The state didn't write back. It's a legal disgrace. And without Mirandaization, he's closing the case. He says, Your Honor, the logic is sound and astute. It all stems directly from a poisonous root. He's serving up his tainted fruit. The fruit, the tainted fruit. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. The state calls a witness, Corporal Javin, so calm. Yeah! Tales of the threats and the verbal napalm. I'm a threat for a reason. He said with a glare, then a scholar on cross-exam says, hold it right there. To prove that this tree has been poisoned for good, let's play my arrest video. It's misunderstood. Oh, geez, here we go. He's playing the tape. He's literally handing the prosecution the very fruit he wants thrown out. You hate to see it. No, wait, you love to see it. The body cam rolls a spectacular own. The seeds of his legal demise are now sown. Citing Pennsylvania versus Men's with a confident shout while refusing for 8 straight times to even get out. When her jaw gets broke, it's gonna be your fault. He's proving the state's case without any halt. He's showing the jury with his own evidence the very fresh fruits of a brand new offense. He's serving up his tainted fruit. The tainted fruit. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. Then he calls to the stand his one saving grace, his baby mama to plead his whole case. Tell the jury he asks her if you'd be so kind. Am I the retaliating, threatening kind? She swears on the stand he wouldn't hurt a fly, a claim the prosecutor's quick to deny. Now, ma'am, about that aggravated robbery. He thought to praise his character and opened up the door for the jury to hear of the crimes he'd done before. And the jury comes back guilty, unanimous. He showed them the video of the crime, opened the door to his priors and based his entire defense on a mispronounced legal theory. He served the jury his own tainted fruits on a silver platter. In the end, it was just a fallacy of a mismalice of justice.
Yes, sir. In this case, we're also asking for $5,000 on Mr. Campbell. He's got length of criminal history going back to 2006 in California. Looks like he's been in this area since 2017. What is most concerning for Mr. Campbell is he had 2 failures to appear in 2023. Looks like there are misdemeanor conviction for possession of drug paraphernalia.
Have you ever had a failure to appear?
Possibly. And had a parole violation arrest also in that year. Last year, he had a possession of drug paraphernalia and trespass. So a lot of his issues are misdemeanor convictions here in this jurisdiction. However, again, given those fairly recent failures to appear, we believe that some bail is appropriate to ensure his attendance. Thank you.
Judge, he doesn't have a history of failing to appear. He was not causing any problems when he was stopped for having a whip around his waist, perhaps using it as a belt. Given that...
I love it. This argument is so terrible. This is short, but it's so terrible. First, his argument is that there were no failures to appear when there were failures to appear. Then the first thing he mentions is, well, he had a whip on him, but I think he might have been using it as a belt. I like this attorney too, but this is a rough one.
Particular set of facts, and given a history of a lack of failures to appear, I think there are least restrictive means to keep Mr. Campbell under court supervision, including putting conditions in place, making sure he has regular check-ins and drug testing.
Oh yeah, sure. He's a good boy.
We're seeking an OR in this matter.
I mean, just look at him.
All right. I appreciate that. Unfortunately, high-risk drug offenses fail to appear and fail to comply more than any others, and he's got case with us every year, 2022, 2023, 2024, 2025, consistent with that score. So bail we set at $5,000, bondable. Ovail laws make a court appearance. Next court date, December 5th, and 9:30 a.m.
Okay, that'd be a no.
Guess we're ready, Mr. Peter, if you got the jail.
I do,
All right.
and I'm ready.
Let's do it. Me too. Deputies, what you got there? You can.
There's nothing really more pathetic than begging for bond, generally, but it's even worse on a holiday weekend. This is not for your weekend warriors. This is for your true professional criminals. That's who's rolling around here on a Friday after Thanksgiving, or I think in this case, maybe on Thanksgiving or the day before. But whatever, in close proximity to a holiday, you've got the real pros out there, not just people dabbling in crime.
Start letting one in.
Just sit down.
And what's your name?
Deidre Wilson Smith.
Wilson Smith. Here it is. Deidre Wilson Smith.
Yes, sir.
And I do have your attorney in the courtroom there for you today.
Morning, Your Honor. Douglas Theodore appearing on behalf of Ms. Wilson Smith. She met with Attorney Bove earlier this morning. Attorney Bove went over her rights as well as the 4-count felony complaint, the maximum possible penalty per count. We'd ask the court to waive reading of each enter a not guilty plea schedule the matter for a probable cause conference. She is not employed, so she'd be eligible and is requesting a court-appointed attorney. When the court's ready, we can discuss the issue of bond.
Okay. Ma'am, is that information true? Is that true? Did the attorney went through the charges with you? Possible penalties? They go through those with you?
Yes, sir.
Okay. And then they went through your rights with you as well?
Yes, sir.
Okay. Let's see. Order to be assigned.
That like voice and affect is freaky. It's like something out of a horror movie. It just doesn't fit, and it's weird, and it's just kind of eerie.
To Judge Marsh, order court-appointed attorney set probable cause conference for December 4th at 8:30. Examination date for December 9th. And Mr. Theodore, what's regard to bond?
She's not employed, not on probation or parole. Does have an address which we provided to staff. She's been in jail 5 days. Mr. Bove did explain the serious nature of at least of all the counts, especially count 1. We just asked the court to set an appropriate bond.
Okay. And order your fingerprints to Genesee County Sheriff's Department as well, given the significance of especially count 1, solid intent to murder, no bond at this time.
No bond.
No bond. You can talk to Judge Marsh about it, but no bond at this time. Order fingerprints to Genesee County Sheriff's Department. They haven't been taken. Order court-appointed attorney as well. Okay.
When Goggins no bonds you earned it.
I'm sorry. I didn't hear you.
Guys, I feel like I was pretty respectful when I asked.
They got to take your fingerprints if they haven't taken them. Okay.
But I don't get a bond.
No bond right now. No.
How long will it be before I can go up for a bond again?
Well, you'll be in front of Judge Marsh December 4th.
You said when?
December 4th.
Thank you.
Oh, Judge, can I please have a bond?
Ma'am, I can't. Not getting the charge right now.
The charge is the way it is.
I understand it, but we'll address it in a different date. You're all set.
Oh, Lord Jesus.
Okay, that being no.
Okay, who is the first one, officer?
Yes, sir. First up, I have Mr. Sanchez Jose.
This is fun. I mean, you know, this is all you get near the holidays. People trying to claw their way out of jail, and really cranky judges and court staff who have to be there on a holiday, or not technically, but the Friday after Thanksgiving. But we've got an attorney here. This R.C. Morales, I think is his name. Boy, he's swinging. He's really trying, but you'll see.
So Mr. Sanchez is here on a charge of driving while intoxicated, third time or more. Is with a $50,000 bond with the usual DWI conditions. Your permanent attorney, sir, is a public defender's office. This morning, Mr. Morales from the office is going to represent you. He's going to try to convince me to lower your bond. Then I'm going to hear from the prosecutor, Ms. Hilt, and I'll make a decision as to what happens to you. Go ahead, Mr. Morales.
Good morning on this one, Judge. I actually spoke to Mr. Sanchez myself. I think we've got some pretty good information on him.
I like this judge, and I really hate to say this, and I'm going to take flack for it. But every time that judge talks, I think of Speedy Gonzalez.
He is a 30-year-old United States citizen. We have good contact information for him in terms of an email address and contact through, I guess, a Cynthia Beltran as well. We've got an address over, looks like in the Lower Valley, maybe on Hendrick Street. He's been at that address for 30 years, Judge. So he is a lifelong El Paso resident. He is divorced, has no children, but he's working currently as a barber at the Two Blades Barbershop. What else do I have? No prior military history, Judge. But I do have a note of a mental health issue that I'm not sure if there's actually been a diagnosis for this one, Judge. I'm sure Ms. Hill will hit us with the additional information, but I don't believe that there was an accident associated with this driving while intoxicated third or more. We're hoping for a significant reduction in that $50,000 bond, Judge, so we can get Mr. Sanchez back out and working. I know he does have a home, and he's got he has a home that's his, and so he has payments like along those lines, Judge, significant obligations. We're hoping for a big reduction, Judge.
Ms. Hill, prepare criminal history. I show 3 DWIs, including one prior to or more.
That's correct, Your Honor. And with regard to this particular case, it does appear that there was an accident. Deputy Aguilar responded out to 10300 Eastlake in reference to a subject disturbing. The reporting party stated that he was operating his motor vehicle on Interstate 10 eastbound. He observed a black passenger vehicle in lane 3 directly next to him. He then observed the vehicle swerve into his lane and collided with his vehicle. After the collision, he began to accelerate at a high rate of speed, beginning to leave the scene. The reporting party, along with his wife, began to follow the vehicle. He stated that while on the phone to 911, the vehicle was speeding in speeds up to about 112 miles per hour as per his calculations. They followed the vehicle. It finally came to a stop at the QT gas station located at 10300 Gateway East. At the gas station, the reporting party observed the defendant exit the driver's seat, continue to walk into the gas station. Additionally, the reporting party who had been involved in the accident and his wife attempted to stop the defendant. The defendant pushed the reporting party's wife, went to the restroom. They then stood between him and the vehicle. They didn't allow him to get back into the vehicle. They described him as intoxicated. At that point, deputies arrived on the scene. The defendant was described as having a strong odor of unknown alcoholic beverage. He was slurring his words, swaying heavily. He was asked what had occurred. The defendant was uncooperative and asked how many alcoholic beverages he had consumed, he simply replied with a lot. So based on the defendant's history as well as the accident, in addition to...
I like a lot. A lot is really honest. He was wasted. He did not know how many. But what he was going to say, in all honesty, was it was a lot. I'll say that much.
Fleeing and encountering the parties that were involved in the accident, the state believes the bond is appropriate in this particular case.
He blew up 0.23, almost 4 times the legal limit. All right.
Mm-hmm.
On the part that we had Thurmore, did he go to the pen or just completed probation?
It looks like that one. Let's see, he was convicted in 8/18/2020. I believe it was probation.
Okay.
If I'm off the top of my head, it was 5 adult probation.
Court's going to set the bond of $25,000 with the same conditions that he was given at magistration. On any car he is driving, he will install a camera ignition interlock device. Interlock device in which he's going to be blowing every time he's driving to make sure he's not drinking. 2, he must report to a Pier 1 officer as instructed. That means you will report when they tell you to report. Not when you feel like reporting, not when, oh, I have to do something else, I'm not going to report. Because if you don't report, we'll just bring you back here on a way, way much higher bond. 3, you're not allowed to possess or consume illegal drugs or alcohol. And when you report to Pier 1 officer, they're going to test you to make sure you're not using. And you cannot be rearrested for any new offenses. Also, on any car you are driving, you better have insurance and a valid driver's license. If you don't have a valid driver's license and insurance, you better not be driving any cars because we will revoke your PR bond. Okay, I don't want to hear any excuses that I had to go to work, I had to do this, I had to do that. You don't have a driver's license or insurance, you better not be driving. Thank you.
Thank you.
And Judge, was that straight $25,000 surety or was that a PR?
Conditions. We don't do split bonds anymore.
Okay.
Now it's conditions.
Thank you, Judge.
Hmm?
What is it, 25?
Judge, up next I have Mr. Timmons Jamie.
Bring him in.
I'm off to a rough start, Judge, in terms of what my clients are telling me, but...
Okay, no, hey.
Okay.
Okay, that charmed me. The attorney's like, okay, apparently I didn't get a straight story from my client when I made my opening argument there.
Courtroom 2, let's begin. Who do we have first?
We got position 13, Ms. Holliday.
Okay. This is State versus Deshonda Samantha Holliday, case 25 CR 7627J, accused of terroristic threats and acts and criminal trespass causing damage to property. Ms. Holliday, you've been advised of your rights, and your attorney is going to be Ms. Bader. Would you be, or is it Mr. Merrill? Mr. Merrill, you representing her?
No.
Your Honor.
Ms. Bader? Okay, got it. Any priors, Ms. Harvey?
Yes, Your Honor. Good afternoon. 7 cycles. Last arrest was October 3rd, 2024 out of Clayton County for driving while license suspended or revoked. There was no disposition listed for this case. There does appear to be an active probation case out of Douglas County for financial transaction card theft and identity theft fraud. Sentenced July 15th, 2024 to 5 years probation. In addition, there is a 2021 conviction for driving while license suspended and 2023 obstruction. Nothing further.
Thank you. Mr. Brown, good afternoon.
Good afternoon, Your Honor.
Yes,
is
sir.
good to see you, and I hope you had a wonderful Thanksgiving.
We did. Good to see you too. And what's your recommendation for Ms. Holliday?
Your Honor, based on the facts of this case, we're going to be recommending that she be given a bond as to the terroristic threats or acts count, $1,500 good bond, and as to the criminal trespass and damage to property, a $1,500 good bond as well. We'd ask that she have no further contact with the victims in this case, that she be required to stay away from the incident location, that she be required to relinquish any and all weapons if she has any for the time being, because there were threats of violence and there was a presumption that she did have a firearm on her person.
Warning, this is more depressing than you think it's going to be.
Person at the time, and we would also ask, Your Honor, that she be required to have no alcohol or drugs during the pendency of this case.
Okay. Our litigation managers, we're going to have to write down the name of the alleged victims, or the incident location. So, Mr. Brown, could you allocate those, please?
Absolutely, Your Honor. My apologies. I went right past that. The alleged victim in this case would be her mother, Miss Xavier Holiday, and is the common spelling, Xavier Holiday.
Yes.
And yes, and it would also be, Your Honor, the location as to for the other information that you're looking for is, just one second.
Yeah, the prosecutors have the information. That'll be great, because
the
I didn't
address
write them
is
down. Go ahead.
sure. Yes, Your Honor. The address it appears to be 3871 Red Wine. That is all one word. Road, Southwest Atlanta, Georgia, 30331.
All right. And if there is a Miss Xavier Holiday who wants to address the court, please unmute. You need to unmute in order to be heard. There you go.
Okay.
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
How do you know Miss Deshonda Holiday?
That's my daughter.
All right. And what would you like to tell us?
I spoke with the prosecutor, and I was asking her with the bond condition, could you all require that she get some type of counseling and therapy?
And what kind of counseling and therapy would we be able to provide?
It was like she was on a rampage, and just for the protection of herself, anyone else. So it's like she needs counsel. She experienced a life tragedy.
All right. And is she currently seeking any kind of treatment?
No, and I think she needs some like this. Like she.
Translation: I'm her mom. I've cooled off. Give her a break. And then Judge Lau, precisely what sort of counseling do you think is going to fix the sort of charges that she was charged with? That's why I enjoyed this so much. Listen, and then listen to what she's charged with. It's not the end of the world stuff, but just listen to what she's charged with, and then think, what sort of counseling is going to address this?
She's in court, so I had shared it with the prosecutor. Maybe they can show it to you, but it was something that happened with her as a child, and I have got her counseling in the past, but I think it's something that she needs to. It's something that keeps her and her. So for the protection of herself and others, I think I would like for her to have to get counseling and therapy.
And your street address is Red Wine what?
Red Wine Road.
And the city is?
Atlanta, Georgia.
Okay, got it. Thank you so much. Mr. Merrill? Oh, Miss Bader, excuse me.
Yes, Your Honor. Ms. Holiday is 31 years old. She works at Imperial Day as a lead forklift operator. She does have a good address where she can live with her grandfather, and she also has a brother in the area. Judge, we're fine with a stay away as long as she has a one-time police escort to gather the rest of her belongings. I will note she is 14 weeks pregnant. Judge, we're asking if a signature bond is not possible in this case for the bond not to exceed a $2,000 good bond, $1,000 on each. Thank you.
Yep. On the terroristic threats, that's going to be $2,500. On the criminal trespass causing damage to property is going to be $1,500. This is a $4,000 signature bond through pretrial services level 2. No further contact with Xaviera, Xaivera Holiday.
Yes.
She's to stay away from in Atlanta, Georgia. If she has any personal belongings at the Red Wine Road location, she's allowed a one-time visit with a police officer to retrieve her belongings, and that visit cannot exceed 1 hour. Within 30 days, she must advise the court of her new residential address. Also, within 30 days, she is to enroll or undertake an MH or a BH evaluation and treatment with a qualified healthcare provider and be compliant with all treatment, medication, and or counseling. no illegal drugs, no alcohol beverages, and she's not allowed to own or possess any firearms. Thank you.
Yeah. Hello.
Yeah.
Okay. One thing I don't know. I'm all for what's in the business. My grandkid, she'll be at her grandfather's house.
I don't know where she'll be living, Miss Holiday. That's something that she needs to let the court know.
Okay. No, I was asking for because she has 3 kids, and I know she's not gonna because that's a.
Okay, this is tragic, truly, but also hilarious. She's got 3 kids, and I don't really want to have to deal with them. Can she take them? Well, she can, but it's not gonna. But Grandpa's not gonna like it. I can guarantee you that right here and now.
It's entirely up to her when she comes to the house, who or what she takes.
Okay.
As long as it's not a firearm.
Okay.
All right. Thank you. This is State versus Joseph Williams, accused of simple assault, family violence from October 18th of this year. Case 25 CR 7622G. Mr. Williams, you've been advised of your rights and your attorney.
Oh, this guy's trouble. This guy's trouble. And it's whatever. It's satisfying that he's in front of Lal.
Is going to be Miss
Morel.
Morel? Okay.
Yep.
Excellent. And Miss Harvey, any priors on Mr. Williams?
Yes, Your Honor. 31 cycles. Last arrest was May 22nd, 2025 out of Fulton County for willful obstruction of a law enforcement officer, reckless driving, and fleeing or attempting to elude a police officer. Appears to have an open case.
Grandpa's keeping it real at 70 here.
Out of Fulton County for aggravated assault under 25 SC 003643. Also, the last arrest from May 22nd, 2025 appears to be open under 25 PI 004080, and there also appears to be an open case for simple battery under 23 CR 004266G. The last conviction was from 2007 for possession of tools, and there's a 2006.
How do I put this? I didn't get what you were referring to there. Now I do. You're Queen Purdue. I thought you were referring to another person, and I'm like, wow, that's bold.
Conviction for burglary and nothing further.
Thank you. Mr. Brown? Oh, Ms. Bickerstaff, excuse me.
Yes, Your Honor. Just briefly, on yesterday at 1904 Tremont Drive in Northwest Atlanta, officer spoke to Miss Queen Purdue. She stated that her brother, who is the defendant, they were arguing, and that is when her brother made a fist gesture at her. Another brother had to come break the incident up between them, and that brother also told the police that he saw the defendant clench his fist up at his sister. So given the facts of this case and the open cases that deal with violence, the state's recommendation is a $3,000 cash bond. I'm asking for no further contact with Ms. Purdue to get a one-time escort to the incident location, as that's where he and his sister live. And also no alcohol, drugs, or weapons while out on bond. Ms. Purdue is on Zoom, so the state would sound for her at the appropriate time.
Ms. Purdue, if you want to contribute to the proceeding, please raise your right hand.
All right.
Lower your device, please, so we can see you.
My granddaughter having to help me with this. Okay, can you see me now?
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And what would you like to tell us?
My brother, okay, that's the family home. My sister and I are in charge of it. It was left to us. And he's given trouble for the last 10 years. 3 judges have ordered him off the property. He come back the same day. He don't have any respect for the law.
What's the address? What's the address?
1904 Tremont Drive, Northwest Atlanta.
Is that TROMT?
No. TREMONT, 1E. TREMONT Drive, Northwest Atlanta, Georgia.
All right. Thank you so much.
And
that's good. No, that's good. Thank you.
Okay.
Mr. Merrill?
Yes, Mr. Williams, he's 70 years old, Your Honor. He is a lifelong resident, even with 31 cycles, Your Honor. You didn't hear that he had he had any FTAs, Your Honor, which which signals that he is not a significant risk from fleeing from our jurisdiction, Your Honor. He does have children, but they're all grown, Your Honor. I would mention that, Your Honor, that Mr. Williams, he has severe arthritis in his fingers. And so it's my understanding that he also is an amputee, is that he can't completely all the way straighten his fingers. One thing
let him out, Judge, because he can't completely straighten his finger. Oh, no.
I will point out in the warrant, it says that Mr. Williams was actually bleeding from his eye, Your Honor. And so from my understanding and reading of the warrant, that even if there was a verbal altercation, at some point, Mr. Williams was hit in his eye where the officer has actually observed him bleeding, Your Honor. If a verbal altercation occurred and then he was the one that was struck, Your Honor, that would make someone else their primary aggressor, Your Honor. But be as it may, Your Honor, he is retired, Your Honor. I have spoken to Miss Queen. She did indicate, Miss Perdue. Queen is her first name. Miss Perdue, that she did indicate same information that she relayed to the court, but she also indicated that she's not opposed to him being released. She just wants him to stay away from the property. To that extent, Your Honor, I would ask if I understand you're concerned about his open cases, Your Honor. I would ask if you would set a signature bond. If not, I would not ask that you set a cash-only bond, Your Honor, as he would not have no means to be able to pay the bond. And so I would ask that the bond is set, and if you're not inclined to give a signature bond, a bond that's set no higher than a $1,000 or $2,000 surety bond, Your Honor, as indicated in the warrant. He was the one who was bleeding from his eye.
All right. Thank you. Bond is set at $1,500. This is a surety bond. No further contact with Queen Perdue. He needs to stay 200 yards away from 1904 Tremont Drive in Northwest Atlanta. He's not allowed to return to that location at all. We are going to reset this case to December 11th. Please mute Miss Perdue, Miss Grace, or Miss Lewis. As I was saying, this case is going to be reset to December 11th, along with this other case, 23 CR 004266G. Courtroom 2.
Put your hand down, dummy.
Please unmute. Mr. Williams, you have been advised of your right to remain silent. If you choose to waive your right to remain silent, anything you say can and will be used against you.
Wait for it. This is my favorite part.
In the treatment of your open cases. It's up to you if you want to say something will be against counsel's advice.
Yes, Mr. Williams, I wouldn't advise because she did give you a surety bond. Now, remember, if you say anything, she can go up or down, but go ahead.
Well, I need to speak. I don't have any money that I'm begging for a signature bond. Please, ma'am.
You have too many open cases. You have shown a track record of an inclination. You don't qualify.
How much time I need to do for all of them? I can't get out. I can't straighten my fingers out. I can't fight nobody.
We will see you on December 11th. Thank you.
But anyway, now, can I have a signature bond, please?
You don't qualify. We'll see you next time. Bye-bye.
Don't qualify, sir.
Position 2, Mr. Beatty.
I think I'm in love.
Next case.
Position 5 and 6, Mr. Fletcher.
Nikia Damon Fletcher has two separate cases. Mr. Fletcher, you've been advised of your rights. Your attorney is Ms. Bader. Beginning with position 5, State versus Fletcher. Its charges are simple battery, family violence, and willful obstruction of a law enforcement officer from November 26, 2025. Mr. Fletcher, you have a prior battery family violence warrant from September 1st, 2024. And that case number is 25 CR 7636E. Any priors, Ms. Hari?
3 cycles. The last arrest was December 11, 2018 out of Fulton County for an FTA. There is a 2021 conviction for disorderly conduct and 2019 aggravated assault with a deadly weapon and possession of a firearm during the commission of a felony. And nothing further.
Mr. Brown?
Yes, Your Honor. In this case, the victim is the same person. It is Miss Kiana Rice, who is the mother of their child in common. In position number 5, which ends in 634E, he was asked to get a haircut for their son, and when doing so, the son started crying. She then picks the son up, takes him out to the car. He follows her out to the car, gets into the front seat. After she asks him to get out, he then brandishes a stick, which is also known as a long barrel gun, and then comes around to the other side of the vehicle and then begins to lay hands on her by punching her in the face and torso. The stick, quote unquote, was not found, but it was spoken about by the victim in this case. In the second case, occupying.
Yes, another beautiful Thanksgiving story. This is the Thanksgiving haircut incident, as it came to be known.
Position 6 on your calendar, ending in 636E, Your Honor. That case too also involves Miss Kiana Rice. And in that case, he is charged with a battery, causing intentional leg bruising, visible body harm to her, again, who is the parent of the child, by striking her with closed fists after losing his temper. Your Honor, we would be asking him to have the following bond amount set. As to the count 1 in position 5 of simple battery family violence, we're asking for a $1,500 good bond. As for the willful obstruction, we're asking for a $1,500 SOB through pretrial services. And I did forget to mention that in that case, when law enforcement did find him after he had fled from the location, he then jumped out of a moving vehicle and attempted to flee from the officers when they were trying to apprehend him. And in the case ending in 636E, given that battery charge, Your Honor, we're asking for a $3,500 good bond, FVIP, no further contact with Ms. Kiana Rice, that he is to remain at least 300 yards away from her, that he is to complete a FVIP course, Family Violence Intervention Program, is to have no weapons, no firearms, guns whatsoever, and relinquish them. He is to, in fact, Your Honor, no, and even if he is to, as in the prior case, Your Honor, if he wants to have contact with the child, he needs to go through the appropriate mechanisms legally to do so, unless or until he cannot do so. Your Honor, we would also ask in this case that you require he have no alcohol, drugs, or without a prescription, and that will be the sum total of the state's request, Your Honor, today.
Kiana, I see a Kiana Harvey, so
Yeah, as fun as that was, wait till you see the underwhelming performance of the victim here. It's going to go about how you'd expect, except worse. I mean, yes, of course. It's going to start like this. Exciting and new. But then somehow even get dumber.
I don't know if that's the same person, but Kiana Rice, if you want to contribute to the proceeding, this is the time to unmute and start your video. All right, Ms. Bader.
Yes, Your Honor. Someone wrote in the chat, is the state aware if Ms. Rice is on the call?
She is, it appears she's saying yes 1 second. She's attempting to turn on her video. I believe she's running some technological issues, Your Honor, but if she is not able to do so, it is Ken R, but if she's not able to do so, then we can proceed forward, Your Honor.
Proceed, Ms. Bader, and I'll give her a chance to contribute.
Yes, Your Honor. Mr. Fletcher is 25 years old. He did graduate high school, and he works in a family business there, the restaurant business.
I'm sorry, whose family?
Mr. Fletcher.
Oh, okay.
Yes. And he...
Hi, I'm here.
All right, Ms. Rice, we'll get back to you. Continue, Ms. Bader.
Your Honor, can we hear from Ms. Rice?
Sure.
Thank you.
Kiana Rice?
Yes.
Your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
What would you like to tell us?
Yes, I would like to say he is the father of my child. He is very active in his son's life. That day, We got into a heated argument, and what I thought was a gun was actually not a gun.
What was it?
I'm sorry.
What was it?
It was not a gun. It was his phone.
Okay, I know what it's not. What was it?
It was his phone.
It was a phone?
Yes.
How does a phone look like a gun?
Because I only saw the black part of it. It wasn't all the way taken out. So since it was black, I thought it was a gun.
Why would you think it's a gun?
I just thought it was a gun.
Why?
Because it was black. Normally guns are black. It was not a gun. It was in fact his phone. He has a black case on his phone. I wasn't able to.
She's doing the Serenity Now thing. she just had to tilt back in the chair and take a deep breath for that. She's not buying any of it. She's biting her tongue, but she's not buying any of this freaking story. Not one word of it.
To see the whole thing, I only saw a portion of it. So I did think that it was a gun.
Okay, and what were you all doing at that time?
I'm sorry.
What were you all doing at that time?
Getting our son a haircut for Thanksgiving.
Okay.
And he's not a violent person at all. We just got into a very heated argument. So, that is why the police officers were called there to the scene.
Okay. And who called the police?
I did.
And he's not
Yes.
he's not a violent person.
No, he is not. I only called the police because I was upset. I do get dramatic sometimes. We were in a heated argument, as I said before, and I was upset, so I called the police.
Okay. Thank you. Anyone else who wants to speak on behalf of Mr. Fletcher besides Ms. Rice and besides Ms. Bader? No? Okay. Ms. Bader, you may continue.
Thank you, Your Honor. Your Honor, at this time, these are just allegations. He does deny the allegations against Ms. Rice. Our understanding is that she wants contact. They don't live together, for the record. He does live with his mother in a separate address. So we're asking for the total bond not to exceed a $3,000 good bond total between the cases and no further violent contact.
Okay. Thank you.
Hello, hello, hello. I can't believe anybody's still here. I don't know if you can hear me. I just, everything was fine. There was nothing going wrong, and then it just completely died. I've had zero problems with internet all day. We were almost done, but whatever. Let me see if I can grab it.
Yes, Your Honor. In this case, we're also asking.
And besides, Ms. Bader. Family violence, that's going to be 2,500. The willful obstruction is going to be 1,500. And on the battery family violence from September 1st, 2024, that's going to be 3,000. His total bond is going to be a $7,000 signature bond through pretrial services, level 3. He will report to pretrial services once a week. He will have no further violent contact with Miss Kiana Rice. And he's to file a legitimation case and obtain a court order for joint custody and joint visitation within.
That is so weird. That is so weird. I like Judge Law, but I don't know if you can do that. You probably can. Do I have a family law and a criminal law person? I don't know. She just ordered him as a condition of bond to file a legitimation case. That's insane. That should be his choice, whether or not he wants to file a legitimation case. I don't understand. I'm sure she knows what she's doing. She's very sharp, but it seems so strange to me. My thought was, obviously he can't act right around her. He needs to just get the hell away from her. He can't control himself. The last thing he needs to do is get closer to her, because he'll just end up spending the rest of his life in jail because he's a moron.
60 days of being released. Within
It's not her fault. I mean, it's self-preservation for him.
30 days of being released, he will enroll in a domestic violence intervention program, and he will attend and complete all 24 weeks of classes at his expense. No illegal drugs, no alcoholic beverages, and definitely no firearms. He will be subject to random screens for illegal drugs and or alcohol while he reports to pretrial. Mr. Fletcher, if you don't report to pretrial, if you don't come to court when summoned, if you violate any of the conditions of the bond, or if you get arrested again, your $7,000 signature bond will be revoked and converted to a cash bond only. Thank you. Oh, and this also means no future physical and verbal altercations with Miss Rice. If there are any altercations in the future and the police get involved, that will also revoke your bond. Thank you.
There's no way.
Next case, please.
I hate to say it, but for his own sake, he needs to run like hell. It's his fault. I'm not blaming her, but now one of either two things will put him in jail for a long time. One, he can't control himself. The most likely scenario, he can't control himself and does something stupid and ends up getting rearrested. Two, she gets mad at him and just makes some shit up. Either way, he's going to jail. Either way. I'm not accusing her of that, but I'm saying either one of those things, the likelihood of either one of those things by itself is high. The likelihood of both of those put together is almost 100%. You know, maybe not this week, although the odds aren't that low either. But like over the next couple of years, it's he just needs to separate, or unless he wants to be in prison the rest of his life, because that's where it's going to go. Yeah, she admits to exaggerating, but then basically, when someone admits to exaggerating, that's admitting to, I basically have no credibility. So, do we even believe that, as they say they're, do you see what I'm saying? Like, that means nothing to me, other than we shouldn't listen to you at all. Like, you might be telling the truth at this moment that you have a tendency to exaggerate, or you might just be exaggerating right now. I don't know. In this case, I think, in this particular case, I think she's covering for him and saying that. But that's not mutually exclusive to then going and making stuff up later because it suits your needs in that moment, and you have that kind of leverage over him. I don't know. I thought that was a pretty darn good stream for a thin Friday, Black Friday. I mean, having my internet drop on me for no apparent reason at the end. That was odd. Usually there are signs. Like usually things will start to get a little wonky, and then I'll have some notice. This was like everything was sailing along perfectly, and then boom, just no response. I couldn't do anything. In 1 second. What are you gonna do? Thank you all for coming out. It was fun anyway.